And we'll proceed.
Either one you want to do. Good afternoon, ladies and gentlemen. Good afternoon, ladies and gentlemen. Lauren, your chances of ever getting on this committee are getting dimmer as you keep holding this meeting up. Ladies and gentlemen, I want to welcome y'all to the House Regulated Industries Committee today. We have three propositions that are on the calendar: HB 884, HB 1193, and HB 1400. We're going to start with HB 1193. The mode of operation, so as not to confuse anybody today, since I'll be handling 1400, I will turn it to the point that I present 1400. I'll turn this over to the vice chair to let him preside, and then we'll move forward. Mr. Gambrell.
Thank you, Mr. Chairman. I've got House Bill 1193, and I'm working off of LC 3651.1S. And this bill deals with director licenses and apprenticeships. We'll see that in section 1, the bill addresses the ability for an individual to renew their funeral director's license if they have lapsed and they complete the required CEUs and catch up on the fees that would be associated with renewal. Currently, this is not an option, and so some individuals have gotten stuck, let their license lapse for whatever reason, and we all know that life happens. But for individuals that want to renew and those that are in good standing have never had disciplinary action, that's what section 1 deals with. Section 2 and 3 addresses apprenticeships, and it will remove the current prohibition against reapplying for apprenticeship multiple times. Right now, there was an individual associated with the funeral home in Elberton who was working there and also going through mortuary college and apprenticing. Life got in the way. This gentleman stopped apprenticing and working on school. He then decided after a while to go back and get it done. And he registers for the apprenticeship again. And then he happened to go through a very tumultuous divorce. He got distracted again. Time passes by and he decided that he wanted to go back and finally complete the apprenticeship because his father was getting older and he was going to take over the funeral home from his father. And so basically he was not allowed to do that because the board said he had already attempted twice and that was going to be it. And he was actually told to go to another state to pursue licensure and come back and they would recognize it through reciprocity. So that's what the bill would address in the apprenticeship part. I'm happy to take any questions, but that is ultimately the bill, Mr. Chairman.
Number 17, who is that? Mr. Walensky.
Thank you, Chair. Just so I know where this is coming from, did Representative Bentley or Representative Williams put you up to this?
Well, I'm an honorary member of the Funeral Home Caucus, and I guess officially now, but no, actually, originally neither. I had a friend of mine that was affected by the funeral director license part. I've spoken to some of the funeral directors in my district. And then the apprenticeship part was brought to me by one of the members of the Funeral Home Caucus, and we were willing to add that into this bill as well.
Thank you.
If I might clarify that for your knowledge, section 2 came from the chairman of this committee. Any other questions? Thank you. Number 18.
Thank you, Mr. Chairman. I appreciate the bill, but my question, 2 questions came up to mind, if I may. Is this a one-off situation or is this happening a great deal? That's the first question.
This is happening. Now, I don't have any statistical data of the percentages, but it is happening statewide. And, anytime that we can help individuals who are in good standing that want to be licensed, I think that we should. I think we've run into a situation where the State Funeral Service Board has been unwilling to consider this. And so it was brought to our attention, and I feel like that we need to address it.
Okay. And as a follow-up, Mr. Chairman.
Yes, sir.
So House Bill 1193 addresses a time situation, but would this also address possibly qualifications, like if they have a lapse on their qualification or any other kind of license agreement to remain current or in good standing? Would that also address those situations too?
Well, this would deal with your ability to be licensed or not. And if you have had any type of disciplinary action or you were not able to fulfill the requirements to go through licensure, and I'm not an expert on what all it takes to go through the licensure for funeral director's license. I'm sure it's very rigorous, but if you didn't measure up, if you didn't pass the test, you wouldn't be licensed. So, you have to meet the same requirements that everyone else does. It just gives you the opportunity to renew your license if you have let it lapse within 10 years, and you do the continuing education, you pay the fees associated with renewing the license. And then on the apprenticeship part, if you want to come back and continue your apprenticeship, why should we care how many times it takes? If you're acting in good faith and you are wanting to, work towards that, we should let you do that.
So it does address the continuing education piece?
Yes, that's correct. I'm
Okay,
sorry if I
okay.
missed your question. That's correct.
All right, thank you.
Thank you. Representative Williams.
Thank you, Mr. Chairman. If I could explain a little bit, maybe to clarify. Back in the old days, a funeral director could get licensed through the State Board of Funeral Service. And prior to 1976, someone could work apprenticeship for 3 years under a licensed funeral director, fill out the apprenticeship papers, stand a funeral director law test, and if you pass that test, you became licensed in the state of Georgia as a funeral director. Now, what had happened in 1976, the law stated in order to become, and it changed, in order to become a funeral director, you had to go to mortuary college and become an embalmer also. So what had happened, sometimes after 1976, some people would accidentally allow their license to expire, and they would go back before the state board and ask for it to be reinstated. And the state board would tell them, we cannot reinstate your license. In order for you to be a funeral director, you now have to go to mortuary college and become an embalmer. And this would be within a year of being a lapsed license. So nothing had changed. No qualifications has changed. That was only a hiccup in that law that we could not get resolved until this legislation would correct that. What you have is some people that are now in their 70s and they've never been an embalmer, don't want to be an embalmer, but they have been successful funeral directors and they wish to reinstate their license and carry on with their livelihood. Hope I explained that. I would, thank you.
Are there any questions?
And I'll
There
make a
is.
motion when time.
I think that would be Mr. Carpenter down there.
I was just going to say when the time is pertinent.
All right, do we have any other questions from any of the committee members? This has gone through the subcommittee. If there's no other questions of the committee, what is the will of the committee? We have a motion, we have a second. Do we have any further discussion? If not, all in favor say aye. Opposed, and ayes have it. Thank you
Thank
so
you.
much. Representative Belton, we have in front of us today substitute to House Bill 884, LC 365186S.
Thank you, Mr. Chairman. Thank you, members of the committee, for allowing me to present this bill. I know all of you put a lot of effort into military bills. We passed 54 military bills in the last couple of years. Georgia has the 5th largest military population in America. $28 billion a year comes into Georgia because of the military, $28 billion a year. The Department of Defense is the largest single employer in Georgia. Let me say that again. The Department of Defense is the largest single employer in Georgia. 120,000 military members and 1/3 total jobs. And of course, many of the military bases are the only economic engines in some of these rural areas. The Department of Defense, the Secretary of Defense himself, the largest employer in Georgia, has made a request. He's made a request of House Bill 884. I gave you, hope all of y'all got these different handouts I sent to you. The first one is in yellow is Enhanced Military Spouse Licensure Portability. It's a request directly from the Secretary of Defense. 28 states have passed this policy. Is a picture of here, the green states and the blue states. We are currently yellow. So we're asking that this committee pass a law that 28 other states have done. And that law is contained in House Bill 884. It's the lines 34 through 38. An expedited license by endorsement provided by subsection B shall be issued under 90 days from the date of receipt of an application. That's the essence of the bill. The Department of Defense has asked for 30 days. The subcommittee thought that was too short. Again, 28 states have done 30 days, but I will leave it to the will of the committee. And that, so what we're asking for is that an expedited license be given to military spouses only, within 90 days.
Questions? Mr. Walensky.
Thank you, Chair. The way I read it, and I may be reading wrong, section C, line 34. It says that it shall be issued. However, it doesn't say that if it's maybe denied that it won't be issued. Would it be good to add just at the beginning, if it's approved by whoever, I don't know who approves these, a commission, a group, state agency, but maybe if approved by X, an expedited license shall be endorsement, because it looks like even if they reject it, it still shall be given.
That's a valid point. I lived the legislative council.
Could certainly make that change in subsection B. It does not withstand any other provisions of law. And it sets out the requirement for the expedited license. So I think that does address what the member is highlighting, but I don't see any issue with restating that in subsection C the way he's proposed, if that is the will of the committee.
Chairman Collins.
Thank you, Mr. Chairman. I wasn't in the subcommittee, and I see the author of the bill had asked for 30 days in the original.
The Secretary of Defense after 30 days.
But
Yes, sir.
you want 30 days. 90 days seems like a long time. Maybe split the difference and do 45. But I mean, these people are needing their license. They need to go to work, and they're serving. Their spouses are serving our country, and I don't think it would be too big of an ask to cut that time back down.
Thank you for the question, Mr. Collins. It is true that, again, this is a specific ask for 30 days. I will do whatever the will of the committee. I'll say that we have troops in Poland right now. And when they were told to go there, they didn't ask for 45 days or 90 days. They said they got there tomorrow, and they went to Poland on the border of Ukraine to go to war for us if we had to. So this is a grace that we're asking for these military members and their spouses.
I don't know, Mr. Chairman, you may be able to enlighten us or some folks on the subcommittee as to why we changed it to 90. But I'd just like to say is support to our military families. I think it'd be important to roll that back.
All right. I don't know. I did not sit in on that bill. I did have communications from some of the licensing divisions over the Secretary of State that some of these boards don't meet but quarterly. And they had concerns that due to the fact that they don't meet quarterly, that they could not fulfill the desire. That was the reason it was put at 90 days because of my understanding was because a lot of these boards, and as you, as a member of the undertaker's profession, you understand dealing with your respective board, that sometimes it's hard to get these board members there because they only meet on a quarterly basis. And I think that was the reason it was put at 90 days. But whatever the will of this committee is, but please keep in mind that this committee is very specific. We try to pass forward legislation that's not flawed, that would create any unintended consequences. So whatever the will of this committee will be at the proper time. Mr. Carpenter.
Thank you, Chairman. So explain to me, Dave, I'm obviously, I wasn't a military family, but what's the length of time that people typically, if when they transfer into Georgia, how long are they here?
Usually they're here about 2 years. Again, I was a military child. I was born in the Philippine Islands. Every 2 years you move. And it's, for the first couple months, you're trying to, transition into that particular residence. In the last couple months, you're trying to transition out. And then again, you're going usually halfway across the planet. And we moved from the Philippines to Connecticut, and then Connecticut to Japan, then Japan to Washington, D.C., and then to Italy. So it's not down the road. You're going from one place on the planet to the other. And the military said more than one time, and what I'm trying to do is protect that $28 billion. Let me say it again, $28 billion. I'm trying to protect that because what the military is saying is that, listen, if you can't protect my military spouses, I will move those soldiers to a state that can. 28 states are doing this. And 28 states are saying, we want that military to come here to our state. So Georgia, I'm hoping, is going to say that, yeah, we want our military to be here as well. So when you're saying, if you walk into a state, it's going to take these people, maybe 3 months to start getting their paperwork together, just to make the application. And then they have to wait another 3 months. By that time, you got a year or so maybe of work, and then they got to start transitioning again to another state. So that's why the military is just begging, and that's why we've done all these compact bills. And I really appreciate with all the help y'all have done on these compact bills. The military is just begging us to help these military spouses.
Yeah, I concur with Representative Collins on this as far as, to me, 90 days is a long time. Obviously, they've licensed in another state already. I understand the chairman's point of people not meeting, but on a quarterly basis. But in the age of Zoom and everything else, I think emergency meetings for the handful of licensing we're talking about for those certain committees could be handled via Zoom. And that's just my thought on it. But I agree with you. 90 days is a long time.
If you won't mind, thank you for the question, Representative Carpenter. Most military spouses don't work. Most military spouses are taking care of the kids because the military spouses usually going somewhere else, halfway across the planet. Commander Jackson, how many times do you go away for 9 months at a time? Probably. Do you want your military spouse to be as happy as they could possibly be? And what happens is, let's say I'm in Washington State and I'm ordered to Georgia. A lot of times the spouse will look at what's going on in Georgia and look at all the different laws, and they say, well, it's gonna be hard for me to work in Georgia. Let's just quit the military. Let's just stay in Washington State, and we'll just stay right here. And the military member will say, well, you're right, honey. I love you, and I'm going to stay here in Washington. I'm going to quit the military. We just lost that military member because of the military spouse wouldn't want to move to Georgia. So that's what we're trying to prevent. We're trying to make the military spouse as happy as he or she can be, and giving them this expedited license. And I've worked with the Secretary of State for 3 years on this, asking them to do this by themselves, and they just will not do it. And that's why I'm coming to this committee.
Representative Jackson.
Thank you, Mr. Chairman. If I may, I like this bill, obviously, full transparency. But not only the Department of Defense is investing $28 billion into Georgia, Mr. Chairman, there's nearly 700,000 military members and their families that call Georgia home. At a minimum, when a military family come into a state, they're there for 2 years. But they may end up, as Representative Belton stated, there for a longer period of time. The reason why the Secretary of Defense is asking for 30 days based on Representative Jay Collins' point is that 30 days is when that military family transferred from one place to another. And in their leave, the military give them 30 days. And so that's the reason why that 30 days is such a magical number for the Department of Defense, is because we're giving those military families an opportunity to set up, make sure they got the housing, the children are taken care of, and the military spouse is employed. And so that's the reason why 30 days is such a very appropriate number that should be in House Bill 884.
Thank you, Representative Jackson. I had not thought of that. You're exactly right. Thank you, sir.
Representative Washburn.
Thank you, Mr. Chairman. I was on the subcommittee and this was debated pretty thoroughly there. And there were a couple of members on that subcommittee who are not here today who had real concerns. And I spoke to Chairman Belton about it this morning. Certainly we're in support of what he's trying to do and we're in support of our military families. But there was concern that 30 days was a very short period of time to get information in from other states and to make thorough decisions about it. So I did just want to comment that this was pretty thoroughly discussed in the subcommittee, and there were some real concerns about the time frame.
All right, we have Representative Kirby online.
Thank you, Mr. Chairman. Listening to all this debate and having talked to Representative Belton earlier today, I understand your point about these boards and sometimes can't get together, but these people are appointed and they should be serving willingly. And so at this time, I want to go ahead and make a motion to amend this to 30 days.
At the proper time, you'll be recognized for that motion, even though you'll probably be falling over yourselves to get to all the folks that are wanting to do that. All right, number 24.
Thank you. Yeah, thank you so much for bringing this bill. Yeah, I was raised on military bases. So, we moved all over Fort Gordon, Fort Benning, Fort Wainwright, Alaska, Pentagon, everywhere. And I, for us, it was pretty much 3 years most of the time. My father was an Army Ranger officer. But I am kind of wondering with the 30 days, I'm a little curious about the process for making application for the licensure. I know that when we would get reassigned, we would know a few months in advance where we were going. And I'm wondering, application for licensure in the new state, the destination where a military family might be moving to, that process could be started earlier, couldn't it? I mean, do they wait until they arrive here in Georgia and then have to wait 30 days?
I do not know. I suppose they could.
Like if I knew that 3 months from now I'd be reassigned to, Fort Hood or something, could I go ahead now and online start the licensure process ahead of time?
I know
Kinda cut down
documents
on
have to be
the-
produced. I don't know how exactly that's done. I'm not a
Okay.
licensure expert. I do know sometimes the orders are given very quickly. I mean, sometimes you have a lot of leeway. Sometimes you don't have a lot of leeway. Sometimes you're Commander Jackson, I bet you've been told to go somewhere you didn't not necessarily want to go, and sometimes it could be within months, and you need that to go. And then the spouse has to decide: am I going to continue doing this, or am I going to get out of the military? Because I just this one harsh thing too many. And also, we'll mention. I don't want to muddle the conversation, but the military said that even as a temporary within 30 days would be something they would accept as a green. Something they would say, yeah, you made that the best effort there. A temporary license of some sort within 30 days.
Do we have any other questions from the committee members? I know that we have several members that that want to amend the 90 to 60 to 30. Excuse me. There might be the need to change some language into that section under C. One of the issues that I see would be 30 might be just fine. But these respective licensing boards, if they don't meet or if they don't have the information pertinent on what comes from the other states. And they'd be working in the dark. Now, that being said, would y'all like to take a break on this bill to come up with some other language that might be pertinent? Mr. Carpenter, Mr. Collins,
I think there's a lot of time. Bill's gonna have to go through a lot of hands before it.
well, it's got a lot of hands to go through, but while I'm presenting this bill, this next bill, I'd be more than glad to postpone this bill to the end of the meeting. If y'all can draw up some language. And as the chair of the committee, what I would urge you to take into consideration is one is that these licensing boards may not meet on a monthly basis. They may meet on a quarterly basis. So if they're meeting on a quarterly basis, then perhaps you need to put some language in there that would give cause that the petitioner for license should give or have that information from the state from which they're coming from to be able to provide that. And that may pick up the process a little bit quicker, maybe. If I made any sense of what I just said.
You're saying make sure they got their ducks in a row.
Be sure they got their ducks in the row, Captain. All right. If y'all want to go over and talk to Sean Marie and if y'all want to work for that, then we'll suspend action on this bill. Representative Belton, would you have time to wait around? Or
Of course,
would you
sir.
like to
Yes.
trust this into the
I'll
hands of these
speak with
committee
him.
members?
Yes, sir. If you don't mind, we'll work with him over here.
That'll be just fine.
Thank you very much, Mr. Chairman. Thank you, committee.
Representative Jackson, would you like to work with them also? All right. At this time, I'm going to relinquish the chair to Vice Chair Washburn. I'm going to present House Bill 1400. I would like to tell you that we have a number of people. We have a number of people that are, several people that are going to testify. I have reached out to the legal community. That since the premise of a lot of the basis of this bill to clean up and to cure this situation has been based on legal action and a lot of information that I have been only talked to several learned attorneys that don't have any interest in this issue, but they were going to talk about the legal process, who has rights to file litigation and the such. And they're also going to be speaking in a little while. Two of these are one, Chris Nolowitz, who is they tell me, I've never dealt with him, but they tell me he's a mighty dandy good lawyer, and that he could probably tell members a little bit more than I can about litigation and the right to sue. And we have a lady by the name of Ms. Esther Panic. And they say that she's another expert in the legal field. And I think that she actually is a commentator, maybe. So maybe they can answer any other questions of the committee members. So with that, I'm going to relinquish the chair. And then I'm going to present this bill again, an abbreviated version of the last presentation, I hope. And then we'll take testimony.
Thank you, Mr. Chairman. Chair recognizes Chairman Powell to present House Bill 1400.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee again. You know, I've done all that I could to reach out to the people that are involved. We've had testimony that was given again at a couple of the hearings by the people that are affected by our actions of 3 years ago. And that would be the most important people in this issue. And that's the people who have medical necessity. those people that we listened to 3 years ago. It's regretful that because of the virus and the pandemic and such as that, a lot of those people didn't come forward. They didn't bring the children. They didn't bring the sick and the disabled to talk about the medical necessity this time. But I think a lot of that also had to do with the fact of disgust. I think that y'all may have remembered one of the folks that testified was sort of dead on in his evaluation of how dismal this process has been. That we passed a bill 3 years ago to allow for the processing, the growing and the processing of medical cannabis. And 3 years later, it's still not to fruition. I had said what a terrible process I thought it was, the worst that I could imagine of bureaucracy. I've tried not to blame anybody or any institution because of this. Sometimes things happen, but that doesn't make it right. And it doesn't make it right for these people. We had a situation that the commission was appointed, and y'all already know, and I'll try not to be too redundant, but that 3 years ago, after the process of the conference committee, there were supposed to be 6 licenses issued. There were 69 applicants that were put into that were submitted. 6 were tentatively, not permanently chosen, but tentatively chosen by the commission. Out of the 69 and those 6, there were 16 that filed a protest as allowed by the legislation. And they have filed these protests. The next step, and according to DOS, was under the rules of DOS, was that these people who filed a protest would now be the only people who had legal standing to file litigation. Then you get the situation that a lot of people have come up with ideas, and I've relayed them, and I've listened to all of them, because quite frankly, to the committee members and all of those living in TV land that can hear my voice, that I have continued for over 2 months now. Actually, it's more than that, from when we first heard in the oversight back in November from the Cannabis Commission Director that we need to deal with this issue. And I continue to ask the question, and I've continued to broadcast this out. If anybody has a better solution, bring it up. The solution, as best I have found after talking to numerous attorneys and people that know the process, has been the easiest way to short circuit this system to allow for the up and running of the cannabis commission or the medical cannabis industry is to allow the 16 protesters to be licensed equally like the 6. Now that's a total of 22. And if y'all remember, I spoke about the bill in the last one, that this bill did a few things. The most important, to get to the gist of it, is that it would allow no more than 22 licenses. I don't know that we'll have the 16 protesters. I don't know how many are actually going to go through with it, because, you know, how many farms or how many operations does it take to produce the needed oil? You know, I'm not hypocritical about this, but we all know that this is a business venture for these folks. They've taken investors. They're doing what they're doing. The 6 have already made a sizable investment. Apparently, the protesters have made investments by going through the system. We have a lot of folks, and I have no doubt that a lot of the people who didn't file a protest probably had awful good business models to go forward. But the reason for all of this, and I surmise, is that, you know, it's not just the medical cannabis, but they're looking down the road for the future. And that's fine, because that's American business, but we only know what they're allowed to do right now. And that's to either get a 100 or a 50,000 square foot licensed facility and to start growing to produce cannabis oil for those people who are eligible in the state of Georgia. Now, it becomes all in nature of 2 things. Do we want to allow this to go forward with a legislative fix, or do we want to allow a judicial fix? The judicial fix will be if any of these protesters that have standing file litigation. If they file litigation, then what I am told, and understand, I'm not an attorney. But what I'm told is that they will file in the Fulton County Superior Court, where this capital is located. And that I am told that it could be upwards of 18 months plus before litigation is ever heard in the Fulton County court system. I don't know if that's normal or not. Being a lawyer, it doesn't seem to be a very attractive possibility, but that's what I'm told. Then you've got the appeals to the Court of Appeals and to the Supreme Court if necessary. And that tells me that we're looking, and what I'm told by the learned professionals that litigate, that we could be looking at 3 years. So you add 3 years on top of 3 years. So I would tell you again that I'm moving forward with this from an extraordinary process that I've never been faced with. And that's to try to craft legislation to move a process forward to avoid litigation. And that's quite frankly what it is. Myself, as well as a lot of you on the committee, haven't heard from the 6 that have been tentatively approved. Well, finally, they came forward. And as I had said, I'm not an attorney and I should have realized, but one of the reasons that those 6 have not said anything, not only because they've been tentatively approved, but under advice from legal counsel, that if they've been pre-approved, stay out of this fray and let the legislature do their business on it. Several issues. Most primarily that under this bill, that we would basically license the 16 protesters. Is that fair to the others who didn't protest? Nah, it's not fair, but they didn't protest. And I'm sorry they didn't, but that would have created more. I remember 3 years ago when this bill came up, I'm a big believer in the free market and the free enterprise system. This whole issue would have been negated if 3 years ago, if we had had an open number and just let the commission choose ever how many they wanted to, but that wasn't done. It was left at 6. A couple other issues in the bill that are noteworthy. I think that most of the members that are here today were here in November when we had hearings, probably in this very room, that we called in the Cannabis Commission, and the director or the executive director showed up. And it was absolutely the biggest waste of time that I think we've ever spent. He could not answer a question, period. Would not, could not, because under his belief of the law was passed 3 years ago, it said that he couldn't reveal any information. Now, I remember myself as well as you did not ask, nor did you care what was trade secrets, because that's none of our business, nor the business models, but it was about the process involved. And they couldn't share that. To the point they couldn't even answer. He couldn't even answer a question in his mind about did they use any consultants to help judge. So everything we've been doing has been somewhat in the dark, even though we've been asking questions. And I thank a lot of y'all for your involvement, that we have been working on this bill to try to reach a solution to it. So because of that, there's a couple other parts of this bill. One is that we have established that the House Regulated Industries Committee and Senate Regulated Industries Committee will be the oversight committees in the future of any of this Cannabis Commission business, so that we can actually look over them and administer the Administrative Procedures Act to this commission, so that they will have to report to the standing committees upon asking. I wish we could go further, but since the Georgia legislature does not allow subpoena power for sworn testimony like they do in some other legislative areas, that's the best we can do. Because if there's anything that I think needs to have subpoena powers, it's this issue, but it's not. So that was put in. And to the betterment of not only the legislative members, but to the public and to the news media, we have now abolished in this bill that cloak of secrecy. We've opened it up to transparency, so that anything not covered under other code sections, such as the protection of trade secrets, that upon request, they're going to have to let us know just exactly what they're doing. But that, ladies and gentlemen, I will say it again, this bill is about one thing, and that's about moving this thing forward without haste to move us toward getting these operations up and going. Now with that, I want to step aside. There are people to testify. A lot of the ones that are testifying, I'm hoping are going to be a lot of the protesters that can say whatever they say, because if y'all remember when I presented the methodology that the commission evaluated last time, it was the worst possibility I'd ever seen. Y'all might remember that I equated it to me assigning a bill sent to this committee, a section to each one of y'all, and telling you don't look at the other parts of the bill. That's what it was, and that's for the reason there was a failure in the due process of the application evaluation process. So with that, Mr. Chairman, I'll be glad to answer any questions of the committee, even though I think y'all know the issues. I will step aside for testimony for the other folks. And by the two attorneys that I understand, one online and one in person today, these are the skilled attorneys. They're not representing any clients or anybody in this, but they're skilled litigants. And for those of y'all who may have any questions or would like to relay the question to some of our other members who continue to think that we can just open it up to 6, that won't create litigation for the other 10, you need to be able to tell them that. For any of those that think that that we can allow the governor to pick which one of the 6 that's been pre-approved, well, that ain't gonna work, because then not only will the protesters have right for suit, then the other members that have been temporarily assigned or given the okay, then they'll have litigation. So this is a very interesting issue, folks, and I want to thank you for your indulgence, and I will step aside if there's no questions so that some of these good folks can testify.
Thank you, Mr. Chairman. The board indicates that there are no questions at this time, so we'll start recognizing our witnesses. The first one on the list is Ms. Aviva, I believe, with the Georgia Hemp Economic Revival Organization. Ms. Aviva, if you would testify.
Thank you, Mr. Chairman, members of the committee, everyone watching. My name is Aviva Vuvuzela. I represent the Georgia Hemp Economic Revival Organization. I feel really good about this bill. There's a good sign, 22 farmers on the 22nd day of legislation in 2022. There is a good chance that once we open up the market, we're going to need a lot more medicine also. So that is a great reason why we need to expand it. I recognize a lot of you might be uncomfortable with the cannabis conversation. It's unfamiliar and you want to make sure you comply with federal legality, and it's uncharted territory. You might even have fear because of how you've seen cannabis affect people negatively in your lives. But there are many sides to this, and I ask you to meditate on how, if someone uses cannabis in a negative way, it's the person using it this way that needs help. It's about putting our focus on where the real problem is. I ask you to remove your worry and pretend for a moment that all that matters right here, right now, is your common sense in this moment, as I bring up some very basic logical issues. Cannabis is one genus of plant that has been federally divided, I think to its detriment, into hemp and everything else being above the 0.3% THC federal limit. But what some of you might not know is that in the 1930s, there was over 40,000 acres of industrial hemp growing in Dearborn, Michigan, that George Washington Carver and Henry Ford were using chirurgically to make car frames and fuel for vehicles. I want to know where that seed is today, because I guarantee you that hemp had more than 0.3% THC. What I have seen the past few years working and speaking with farmers internationally is that it is practically genetically impossible to harvest a cannabis plant at full maturation to maintain the government-imposed limit of 0.3% THC. You must ask yourself, why do we feel, and why does the government feel, that we have this entitlement to mess up the natural design, God's design of this amazing plant? And trust me, I think breeding it to have ultra high THC is also damaging. For example, full maturation of the Dearborn, Michigan crop would be anywhere from 6 to 14 feet high. Harvesting it today to keep the 0.3% THC limit would mean maybe harvesting it at 3, 4, or 5 feet, which means as a farmer and processor, you lose more than half the herd fiber and oil potential, which is a huge loss in bounty and economics. This crop in the 1930s was probably closer to 1% THC at full maturation. Cannabis is very wise. Though the French-Canadian geneticist grew a 0.3% THC seed in chilly Canada, in southern climates and southern heat, cannabis adapts by producing more of this natural sunscreen, the THC, which also acts as a sunscreen to the earth. More on that in a moment. So not only has our Georgia legislative body, with the excuse of following federal flawed laws, passed legislation that ignores the true nature of the cannabis plant, supporting the belief that completely manipulating a God-given seed to suit our control needs. But because of this, these Georgia laws are hurting Georgia farmers and thus the Georgia economy. And I feel it's all of our responsibility to do our due diligence and look into what I'm sharing further. Not to just take the word of those selling the seeds, but those sowing them. So this is why I'm telling you all of this. What I'm asking of you today, because I believe this committee holds the power to do something really fantastic today, not only by passing this bill, but it would be very intelligent and morally correct. Now that low THC oil is legal in Georgia, we have a market for the hot hemp that has grown by these farmers. And there is no logical, compassionate reason why medically approved cannabis farmers and processors couldn't buy that hot hemp. They're actually giving New York hemp farmers in a bill that they're working on, actually temporary medical cannabis licenses. Therefore, these therefore, these hemp farmers who have put their neck out on the line by planting a science experiment don't lose everything, including their minds. And please remember, THC is not the enemy. The THC trichomes, though you may not like the smell, have incredible powers to not only cleanse our environment through sticking to the pollution, but pulling toxins out of the atmosphere, and they microscopically reflect photons, and through this reflection, they create atmospheric shade like trees, protecting the earth. It would serve the public in ways you can't even imagine if you begin to see the gateway into cannabis learning and admit there is so much we don't know, instead of seeing cannabis as a propagandized gateway to dangerous self-harm. What is dangerous is playing God. And I truly believe honoring God's gift to humanity, cannabis, will help all of us. Speaking of which, you also might not know that 16 years ago, there was a unanimous Supreme Court decision to protect cannabis as sacrament through the Religious Freedom and Restoration Act. It was upheld once again in 2014. Cannabis is regarded as a sacrament, and now is the time for her and him to be treated as such. I have a song, if you're willing to hear it today, if it's the will of the committee. I could also sing it later when you might need an energy boost.
I'm sure she will be, Mr. Chairman, and if it won't take too long, we'll be delighted to hear it.
Thank you so much. Yes, I ran into Representative Mitchell at one of my gigs, and he said, bring your ukulele, so. So that night I wrote this song, Sunday night, just for you all. It has a Hebrew word in it, which you might not recognize. It's called chokhmah, which means wisdom. And I allude to the story of King Solomon deciding who the real mother is of a baby. King Solomon declared his judgment. The baby would be cut in two. One of them agreed, but the other one begged him not to follow through. Chokhmah, where does the real wisdom lie? Chokhmah, the real mother saves the baby's life. Pure cannabis is being whacked by a society of quacks. Pure cannabis just isn't treasured. It's being judged, modified, and measured. Even split apart and labeled. It's our right to grow our own, but that's tabled. Chokhmah, Solomon grabbed that sword. Chokhmah, true wisdom isn't ignored. It's a choice between defending what is right or caving in. Chokhmah, Chokhmah. It's a choice between compassion and the will to win. Chokhmah, Chokhmah. Chokhmah. The real mother wouldn't play along. Chokhmah. She knew it was wrong. She knew it was wrong. She knew it was wrong. Thank you so much. Thank you so much.
Thank you, Aviva, for your testimony and the song. I may have jeopardized my career as vice chairman of the Regulated Industries Committee. I was scared to look over at the chairman during that time. Okay, next we have Dr. Brian Scott of Scott's Pharmacy. Dr. Scott, are you here?
Good afternoon, Vice Chairman Washburn. First, let me say thank you all for convening this committee on this hearing on HB 1400. I know how conducting the people's business can be very daunting, very challenging, different ideas, different views, and I really just appreciate your service for that. Like you said before, my name is Dr. Brian Scott. I'm a pharmacist and I own Scott's Pharmacy in Macon, Georgia. It's a family-owned pharmacy. It was started in 1985 by my father, who's a pharmacist, and my mother, who's a retired lieutenant colonel in the Air Force. I'm speaking to you today in the capacity of a community pharmacy owner, as well as a board member of Gabry, which is one of the companies that did file the protest in this matter. I'm speaking to you for two reasons, and this is to increase the number of licenses, and the main one is just access. When I look at access, I do access in two ways. One, physical access to the medication, and two, affordability of the medication. As a pharmacist, I've been on the front lines of this coronavirus pandemic and have witnessed pharmacy stock shortages that can really affect quality of care. No matter how you feel about the benefits of hydroxychloroquine or ivermectin, during the Delta surges, during the Omicron surges, you couldn't find it at all. Literally, pharmacies could not have it because there are only a few suppliers, and this really started to affect patient care. Even got even so bad that Governor Kemp had to sign executive orders to let small compounding pharmacies like myself compound fentanyl drips, the powerful sedative, so we could intubate patients in the ICUs, because literally we did not have enough fentanyl in the state of Georgia because we had so few suppliers. So when you do this, when you limit the number of licensees to a very small number of companies, you will affect the supply chain and ultimately you will affect patient care. Kind of how Chairman Powell was speaking, it's been 3 years. Imagine if we went forward and only had a limited number of suppliers, patients started getting on these medications, they were feeling better, their pain was better, their seizures for their children were better, and then one day they couldn't get the medication anymore because you only had a few companies and they couldn't keep up with demand. Secondly, cost. Who cares if the medication is available if it's not affordable? While the benefits of low THC oil is undeniable, 99% of insurance companies will not cover it. And because of this, it really will be an out-of-pocket expense. Having a limited number of companies controlling the market may be problematic. You know, you might have a lot of multi-state operators who don't really understand the Georgia marketplace, and their pricing structure may not be in line with, you know, Georgia-bred companies. We all know that the only way to truly ensure competitive pricing is to have good competition in the marketplace. Matter of fact, states that have had limited licensings, like Arkansas and Louisiana, have actually seen their prices outprice the market for their normal patients, which means, once again, they do not have access. My fear is that by limiting the license to so few companies, that there will be an access issue. And by increasing the number of licenses, we can further ensure that no Georgia resident who is using THC oil and is seeing improvement in their PTSD symptoms, their chronic pain, their child seizures, will run the risk of showing up to a dispensary and hearing that we cannot accommodate them because of our supply issues. So that's why I think about access, for one, physical access to the medications, and lastly, cost.
Thank you, Dr. Scott. Next, we have Joshua Luttrell of the Veterans for Cannabis. Yeah, one second. Dr. Scott, the chairman has a question for you.
Yes, sir.
Thank you, Dr. Scott, for your testimony. Did I understand that you said that you were an investor in one of the protesting companies that had protested?
Yes, sir.
One of the premise that I have based this on has been the fact that we have a legal dilemma. And that's, we can either fix this legislatively or let the courts fix it. If the court fix it, we're looking at 3+ years down the road. I have talked to a lot of the protest companies, and they have told me that they will be filing litigation based on the failure of due process of the evaluation. Do you have any ideas what your company would do?
Yes, sir. I feel that, like you spoke so eloquently, this whole process was marred in a lot of non-transparency and things like that. And we feel like it's only fair that we exercise our right, one, by filing the protest, and two, if that protest is not, handled, then the next step would probably be litigation. And we do understand the unfortunate consequence of that dragging on, which is why, we do feel like this legislative bill would be the best way to rectify some of the wrongs of the prior undue process, as well as be the most efficient way to get medical cannabis, to the patients of Georgia.
Thank you.
Thank you, Dr. Scott. Mr. Luttrell, and you certainly can sit there if you prefer. I'm sorry. I did not see that.
That's okay. Thank you, Chairman. It's more of a comment more than anything. That's the first time I've heard the issue of cost. And I appreciate you bringing that, because we haven't discussed adding more people to the marketplace is going to reduce the cost for Georgia patients. So it's something we should support. Thank you.
Okay. Chair recognizes Joshua Luttrell for his testimony.
Absolutely, sir. Thank you, Mr. Chairman. Mr. Chairman, thank you so much. And thanks just for allowing people to speak today and really help you all understand what's going on. I'm Joshua Luttrell, founder and CEO of Veterans for Cannabis. We've been at this process for 8 years almost now. You guys heard from Dale Jackson last time, and Dale and I and so many other patients and mothers and parents and veterans have been trying to bring this to fruition. Chairman, you said something earlier that absolutely hit the nail on the head. People didn't come out because they were disgusted last year. And we were one of those groups that didn't come out, because I can tell you all right now, your veterans are pissed, super pissed, and they want this to be done and over with. They want medicine, because you all see this right here. Can everybody see this right here? These are medicines, and this is just about every single veteran's medicine cabinet and what it looks like. This Narcan that they send you so that if you overdose, your husband or wife can actually take care of you. This doesn't kill anybody, and this is made from cannabis, from the industrial hemp that is grown right here in Georgia, that we've been growing for years. We can save lives, but we need a higher potency as well. So that's one of the things the medical cannabis does. So the things I wanted to bring to you all today is to help you all understand that the veterans are so upset. And you think about the January 6th insurrection or whatever it was, so many veterans were included in that because they just don't believe in the government anymore. They don't believe in this process anymore. And it's been point proven right here in my own state. I'm from Rabun County. Georgia boy, born and raised, and I was raised completely Baptist, really religious. Marijuana was going to make you rape people, rob people, and kill people. And that's factually incorrect. Factually incorrect. That's why I only use cannabis as the name now. But my wife is still active duty. Saw the commander up here earlier. I was going to tell him, you know, she's beat him. She's almost at 23 now, and she's going to retire 29 April. So she has been through this process 8 years now, waiting for medicine for her husband, who is also a combat veteran of the United States Air Force, who hasn't been able to get the medicine. In Florida, I was patient about 11,000, and we've seen that patient registry go up to almost a million patients now. That's phenomenal. I told every single commission that we've sat in front of, we were going to follow lockstep with what Florida had and what Florida has done. So, Chairman, I agree with you 100%. Every single one of these companies that protested is going to sue. We could save taxpayers' money first and foremost and keep the cost down for the state. But above that, we could get medicine to the patients, medicine to those men and women who served and put their life on the line for your freedoms, my freedoms, and our freedoms that we've been telling them, yeah, it's coming. Don't worry about it. Be patient. How many of them have taken their life since we started this 8 years ago? How many of them had died from overdose death? Think about that for just a moment. When we get this done, if we can do these 16, because Veterans for Cannabis was also one of the ones that protested prior to the licensing opening up and post licensure as well. Because working with Representative Peake, Representative Gravely through the years and trying to get this done, it was clear the indication that it was supposed to be Georgia companies made up of Georgia people that were supposed to win these licenses. And I guarantee you the majority of those companies that won are not Georgia based. I mean, we know that for a fact. And some of them had questionable backgrounds. That's a real issue. When we're talking about federal crimes, that's crazy, you know? And these are contractors that are being used that were convicted of bribery in federal court, and they won a license here in Georgia. Unbelievable. That's why the veteran community is so pissed off and so done with this process. But once again, we're here to beg and plead for the medicine that can save our lives, that these kill your veterans every single day, and cannabis does not. Those 16 companies followed the letter of the law that says a party's or applicant's failure to strictly comply with the pre-award protest procedure or to raise any challenge to the competitive application request for proposals process prior to the closing date waives any and all rights for protesting or participating in any protest, and further waives any and all rights to bring such claims in subsequent administrative appeals or litigation. So they didn't do it. Nobody else, they can sue all they want, but they're not going to win. These 16 companies will win. So the question is, do we have competition and help the market bring prices down and help veterans and patients get access to the medicine on a more cost-effective manner? Because every state that has limited licensures has seen that cost skyrocket. And this is something that's not covered by anybody. Not only that, every one of those limited licensure states has issued additional licenses. We could set the standard here in this great state of Georgia that I'm so proud to be a part of and say, hey, you protested, you did everything to the letter of the law. Guess what? We're going to circumvent that process of litigation, and we're going to grant these licenses because they're coming, whether we like it or not. But if we have competition, help that price immediately, we can make it happen. So I'd love to take any questions you all may have. We've been at this a number of years, and hopefully we can shed some light on anything.
Thank you, Mr. Littrell. We do have two questions. Representative Lewinsky is online. Representative, are you there?
I'm there, Chairman.
Okay.
Simple question. The bill we have in front of us, are you for or against this one? I was just a little confused.
Can you hear the question?
Yes, sir, I did. And I do support this. Veterans for Cannabis, the group that we've put together, we sat down with a number of veterans throughout the state and said, hey, do you all support this? And they support it for two reasons. One, it's going to create competition. And two, They were so disgusted that Georgia companies weren't issued licenses that they threw their hands up and they were so done with this. So we want to see Georgia companies owned by Georgia citizens take care of Georgia's patients, because we know those companies will do the right thing.
Okay, thank you. You have another question. Is that Representative Earhart, Representative Williams?
Thank you, Mr. Chairman. First of all, thank you for your service.
Thank you, sir.
Thank you for your wife's service.
Absolutely. Thank you.
And we owe you a great debt of gratitude for all of your service. We're as disgusted as you are. If we lose one person to suicide, if we have one more person suffer one more day, I agree with you wholeheartedly. We're all as disgusted. So please understand, our chairman, Powell, he's come up with what we think is what we need to do to fix this. We're ready to move forward. I'd like to see them producing and manufacturing tomorrow. And I mean that, so help me God.
Absolutely.
Thank you.
Thank you, sir.
Thank you, Mr. Chairman.
That's the last question we have. Thank you, Mr. Littrell, for your testimony. Next, we have the Right Reverend Greg Davis. Reverend Davis.
Thank you, Josh.
Thank you, sir.
Thank you.
Thank you, Chairman Washburn, Chairman Powell, or should I say? For this committee, appreciate y'all. And I want to correct something here right off. This issue's been going on for 40 years. The Controlled Substance Therapeutic Research Act 43-34-120 is still on the books. It's still law. I asked Secretary of the Senate, I said, do you realize that I said, I want you to know I've been lobbying here for the medicine. And I said, you know that law is still on the books? He said, oh no, that law gone with the wind. I'm right in his office. I said, is that the code? Is that Georgia code? So, well, of course it is. I'm the Secretary of the Senate. I said, well, pull it off. 43-34-120. The intent of the legislature is there in 43-34-121. You can read it. It's Georgia law. That's never brought up during any of these hearings. Alan Peake told me on day one, I brought it to his attention. Y'all have that. Naturally derived dronabinol. That's the name of this medicine. This is the Regulated Industries Committee. You don't regulate medicine. You're talking about medicine here. I healed my first patient of non-Hodgkin's lymphoma in 2009. After watching Run from the Cure, the Rick Simpson story. I went to Jamaica and came back with condoms full of hash oil. And one was a leaker. That was a rough trip. So Sharon Cooper on 2014, she said, I told her, I said, you have to have this in non-civil judiciary committee. That's where this has to be. She said, I talked to Rick Allen. I said, you're going to hear from Rick Allen. Rick Allen testified in those hearings, and he said, we got folk out there now cooking up medicine like granny around the cement pond. And that's still going on today. That's where this ministry gets medicine from, literally. So I'm not here to speak out. I got the mystery of what's going on here, Chairman Powell. And I know you're upset with all of this, and I feel for you. I do, believe me. You know I do.
I was standing right there when John and Mo and you, this ministry had already set the stage for the sandbag. The Senate sandbag, it's my legislation. And you asked, what can we do to fix this mess? Because it's a mess. It's not just a mess here in Georgia. It's not just a mess here in this country. It's a mess in Australia. It's a mess in England. It's a mess all over the world. This is the tree of life. When I first was told that, I said, Donnie, I wish that was true. There's got to be some kind of doctrine to back it up. But I don't want to take up a lot of time on all of this because head starts going in. I have trouble with it too. I heal people. I treat people of pain management. You've got this right here. Pain management. That's naturally derived dronabinol. That's the name of this medicine. You take a look and the fine print is here. In the fine print. The DEA will not license this. It's FDA approved for marketing as a Schedule III medicine by the FDA. They won't license it. There is one approved formula, and that's the generic substitute for what's it? Anyway, it's in the paperwork. But I want to finish now because I know this is tough. And so you asked Chairman Powell, Chairman Washburn, what can we do to get medicine to Georgians? What can you do? You can ask Chris, I can't remember his name now, Chris Carr, thank you. You can ask Chris, you can ask him. Ask him this. Are the monastery of the Holy Spirit exempt? Can they grow cannabis at the monastery of the Holy Spirit? And I'll tell you the answer right now, that Peter Skandalakis told me on the 3rd floor. Yeah, they're exempt. They can grow it. I'll contract with them because I'm exempt too. And I'll ship it to the specialty pharmacy that this ministry. Okay.
Okay, Reverend Davis, thank you. We do have one question from Chairman Powell. Mr. Chairman.
I want to thank you and the dialogue and, gosh, we've talked.
Right.
Everybody's got a right to be heard.
Thank you.
I mean, quite frankly, I think you lost me with the condoms, but the purpose of this bill, this is a hearing not on the ministry of marijuana or anything else. This is about specifically how do we fix the problem so we can get this cannabis commission on board and get these folks licensed. Do you support House Bill 1400?
I'm in a different jurisdiction. You're taking on criminal, you're talking about due process. This is criminal due process that's involved here. This is
There's no criminal due process. This isn't the Judiciary Committee. We're regulated industries. We're going forward to either.
Send it over. Send it over.
So
send it over.
Thank you.
Send it over,
Thank
please.
you so much. I appreciate
Dear
it.
God.
Thank you.
We'll let the Senate have at it.
Thank you, Reverend Davis. Next, we have an online testimony from Marcus Farrell. Mr. Farrell, are you available?
Yes, sir, I am.
Okay, if you would, go ahead, please.
First, thank you, Chairman, and thank you, Vice Chairman, for allowing me to speak, and our commission members and committee members. My name is Marcus Farrell. I am the owner of Eagle Farms. We applied for a Class 1 and a Class 2 license here in the state of Georgia. I am a veteran I live right here in the great city of Hateville, which Atlanta happens to be a suburb of. And I'm here because I do like HB 1400. I think this is it's a step in the right direction. However, I do think it's lacking and it's missing one thing, and that is I am one of the companies, and I applied for both licenses, and I am a Georgia-based company that did not appeal for did not put in an appeal against our initial scoring. And I have what I propose as a preliminary matter is to consider expanding HB 1400. In the application process, there were 69 scored applications submitted by 48 different companies. 3 of those companies have either terminated operations or have been administratively dissolved by the Georgia Secretary of State, leaving 45 companies still around that have applied, 39 of which did not win a license. The 15 companies that filed administrative appeals and 1 company that filed a federal lawsuit. And this bill, very nice in expansion of the federal of the cannabis companies awarded, is not going to stop the 11 other companies from filing further federal lawsuits because of not addressing the grievances that have happened in the due process of scoring the applications in the first part. HB 1400 seeks to enlarge the number of licenses issued to 22, essentially awarding licensure to the 16 companies that have either filed administrative appeals or sued. HB 1400, however, allows the issuance of 28 private licenses in total, leaving 6 to be accounted for if the bill passes. Essentially, that leaves 17 companies, or 11, depending on the 6 excess licenses created in the code without a license, and the majority of applicants receiving license regardless of the scoring in the application process. That is 17 potential new lawsuits if the 6 current awardees are deprived of their licenses that can be expected to sue. That's 23 additional suits in addition to 16 already in existence. Any way you slice it, there's a significant number of existing or potential litigants against the state depending on the outcomes here, and any which could slow the process of getting medicine to the growing list of Georgia patients. Despite
Mr. Farrell, we've lost connection, I think. Are you there? I'm sorry, Mr. Farrell, we've lost connection. Chair recognizes Esther Panich, who's also online, I believe. Is she there?
I am, Mr. Chairman.
If you will, go ahead with your testimony, Ms. Panich.
I'm sorry. Am I on?
I'm sorry, Ms. Panich, we're back on with Mr. Farrell. So, Ms. Panich.
I'm sorry about that. I don't know what's going on with my internet.
I understand. We'll go back to Mr. Farrell. Ms. Panich, if you will wait just a moment. Okay.
And thank you, Mr. Chairman. Thank you, Mr. Chairman. I really appreciate you taking me into consideration, despite my horrible internet here. Our proposal is generally this: add to the current HB 1400, develop a 3rd class of license and issue it to the companies that are in the code. A class 3 license would potentially allow for, say, 25 square foot cultivation. And if the existing companies gain a license, there is nearly 0 reason for them to continue to complain. The amendment of the law should state that 45 licenses issued, all that are to be issued for only 5 years. Any license lost or surrendered would not be replaced. Once companies receive notice of intent to grant a class 1, 2, or 3 license, they must prove funds within 15 days or a similar time frame. Failure to show proof of funds or continued existence as an entity in Georgia would further potentially reduce the number of companies crossing the finish line down from 45. We also know as a practical matter that becoming operational within 12 months will be a significant challenge for many companies because of things like the power grid and being able to have enough electricity and energy to actually use a sustainable growth. Expanding the number of licenses, expanding the number of companies producing cannabis oils does provide a better market for patients and represent a net gain for all of them. We would introduce for an additional measure that companies with licenses could possibly merge or acquire other licenses. Let's say a class 2 licensee would acquire a class 1 or class 3 licenses or vice versa. We feel that will prevent the loss of economic development companies undertaking in 12 months, leading to sale of the medicine. Please recall the companies that applied were able to direct tens of millions of dollars worth of resources towards the state of Georgia just in the application process alone. This is a boon that we should not easily ignore or potentially lose. I would like to submit a letter, if at all, Chairman, to the state and to your committee. Basically, just restating what I just said. I am in the process of wanting to make sure that Georgia veterans and patients get medication as fast as possible. But I'm also a minority business owner in this state, and I want to make very sure that that because of the due process that was kind of lacking during this and the amount of economic resources that we put into this license, that we get a fair shake at it. And I do not want to continue down this path of litigation to make sure that the process is fair for everyone. Thank you, committee, for your time, and I really appreciate everyone in here.
Well, thank you, Mr. Farrell. We do have a question from Chairman Powell.
Thank you, Mr. Farrell, and I thank you for your testimony. If I understand what you said, that your company, that y'all did submit an application for licensure for both class 1 and class 2.
Yes, sir.
And but I also understood that your company did not file an appeal. They did not file a protest.
No, we didn't, because we were waiting on the decision that we thought would affect everyone, because of the lack of due process, really, and the application itself. We figured, because in most states, and I guess they call it precedents. Precedents is they revisit the law itself, and they revisit the scoring process itself, like in Illinois and a couple of other states that have been caught up in lawsuits. And that's why we kind of sat back and waited. We wanted to see exactly what the state was going to do, and we do like the direction that the state is going, but on the same token, on its face and on its head, we feel the protests were a protest of a process that was not necessarily a process that was not necessarily clear and transparent. So if you're protesting, but the changes you make, and folks are going to get awarded the license anyway, even though we don't even know why we were scored the way we were scored. Our company was told that spelling errors kept us from getting a license. That was the response from the state, telling us that I put $2 million in the bank account, and the reason that my application didn't get graded right was because of a spelling process. And I mean, a spelling error. And I just say to myself, that's a little backwards. We could have filed, we decided not to, because in most states, and this is not my first rodeo. We have operated out of Atlanta. We have operated in Arizona. We have operated in Colorado. We have operated around Ohio, and we have consulted in many other states across the nation when it comes down to cannabis production, grow, process, and also the distribution of cannabis. But no, we did not file, but the option is, there are plenty of options that are still on the table for my company personally.
So you're not, I guess the first thing caught my attention, you're not a Georgia-based company.
Oh, yes, we are. I'm a Georgia-based company. My company is right here in Atlanta, Georgia. It's been registered here in the state of Georgia since its inception, and I am a Georgia guy, fully and foremost. How else would I know about Hateville?
Well, I thank you for your willingness to testify, and I can only say my explanation is the reason that we have, in House Bill 1400, that we have carved out licensure for the 16 protesters, was because what I have been told, and if I'm wrong, then I stand corrected, But the powers that be have told me that under the DOES structure, that since there was a protest period allowed under the legislation 3 years ago, that the only ones that would be acceptable for litigation would be the protesters, the ones who actually protested. Does not mean that's carved in, because as I frequently said, all it takes is a word processor and a certain level of money, and anybody can file a lawsuit. But it's almost like what I am told is there was one company that filed a federal lawsuit. They didn't file a protest, they filed a federal lawsuit. But what I'm told is that none of the federal courts are hearing any of federal lawsuits based on this, because it's against federal law. So, and I'm sorry, it'd be nice if we had stuck to the principles that we should have, maybe, that if it had been unlimited number left up to the decision of the Cannabis Commission 3 years ago, we may not be sitting in this room today trying to correct the problem that was created because of the process of the evaluation of these offers. So thank you so much.
Thank you.
Thank you, Mr. Chairman, and thank you, Mr. Farrell. Next, we do recognize Ms. Esther Penich for her testimony.
Thank you very much, Mr. Chairman, Mr. Vice Chair, members of the committee. I just want to start by saying something I heard that Chairman Powell mentioned when he was giving his remarks from the floor, and that was that he believed that this process could take up as long as 3 years. I don't mean to burst anyone's bubble, but that's being exceedingly optimistic. In this case, I say that because I just had a case come through the Georgia Supreme Court, starting at the trial level, going through the Georgia Supreme Court, and it was a case about a constitutional issue related to a statute that the Georgia legislature passed and signed into law. It happened to be the Hidden Predator Act, having nothing to do substantively with this statute that you're arguing about today. But in terms of procedure, my case was a 2017 case. It was appealed in the middle of the case in 2019. It was docketed in early 2020. It was heard in oral argument in February of 2021. We received an order, fortunately for my client, we won, but that wasn't until June of 2021. And then it takes months to go back to the trial court on what's known as a remitter, until the trial court takes it back, accepts jurisdiction back, and then schedules it on its calendar for the next available motion or trial date. And it is now February of 2022, and my client's case is still not back on a calendar. So in terms of procedure, it is we are 5 years out from the initial filing of my client's lawsuit, and we still have no resolution. And we've been through the Georgia Supreme Court. And I say that because this is a case, if the lawsuit is related to the constitutionality of this statute, and given that it's a due process argument that sounds like where it's headed, that is a Georgia Supreme Court jurisdiction, not a Georgia Court of Appeals jurisdiction. So you are being optimistic if you're looking at 3 years. I certainly, don't try to talk people out of going to court, because that's what I do for a living, although I'm not involved in this case. But really, you are looking at a long haul if people want to take this through the court system. It is not intended to go through the court system. The courts usually look at you all as the legislators and say, can you fix it? It's not our job to fix it. So you may not be happy with the result one way or the other, and it could be sent back to the trial court. I mean, once you start on this process, you have no idea how it's going to end. You lose control over the process entirely. So generally, we tell people, and I'm not weighing in on the merits of this bill, but generally, when there's an opportunity to keep people equally unhappy, you take that, as opposed to trying to make everyone happy, because at the end of the day, after a trial, most people, no one's happy. In terms of what you've heard about due process, I just want to kind of give some big picture kind of analysis of what due process means. The lawyers here have heard enough, know enough, probably going to roll their eyes. They're going to be reminded of criminal procedure and civil procedure classes and may want to fall asleep. But generally, very generally, due process is a commitment to legality, which is at the heart of all advanced legal systems. Due process embodies that commitment. It promises that before depriving a citizen of life, liberty, or property, the government must follow fair procedures. So the question becomes, what are fair procedures? And there is no real list of definitive required procedures that due process requires. It's kind of up in the air, and it depends on the facts of a particular case. There are some guardrails and some, highlights that people look for, such as an unbiased tribunal, notice of the proposed action and the grounds asserted for it, the opportunity to present reasons why the action shouldn't be taken, the right to present evidence, including the right to call witnesses, the right to have opposing evidence, the right to cross-examine adverse witnesses, the decision based exclusively on the evidence before it and not what somebody may have heard outside, the opportunity to be represented by counsel, the requirement that the tribunal prepare a record of the evidence presented, and the requirement that the tribunal prepare written findings of fact and reasons for its decision. I listened to the testimony from last week just to get a sense of where we would be here today to prepare for my remarks. And the one red flag that kind of still sticks with me is that the appellate procedure was to be led, in my understanding, by the same person or the chairperson who was supposed to be granting the licenses. That's a giant red flag on its face, because what are the different criteria that person is supposed to use, if there are any? That person has already heard the initial application, and now they're expected to weigh in on the appeal. How are they to know, what standard do they usually use? In courts, when you have a judge acting as the fact finder and the finder of law, they have different standards at different parts of the case. And so they know through which prism to make their decisions. I don't know that was addressed as part of the commission and as part of the role as the director, for the director. But that shot out at me as a giant red flag, which I assume would be part of any litigation that goes forward. I also just heard some questions related to standing, or that at least brought up the idea of standing by the exchange by Chairman Powell and Mr. Farrell. And essentially what standing means is who has the ability to sue. And in Georgia courts, I'm not talking about the federal courts, in Georgia courts, the elements of standing are set forth that you have to have an injury, a proven injury. So I guess somebody might argue that they were deprived of a property interest by not being able to be granted their license. And that there is causation. There has to be a link between the injury and the action of the other party, and redressability. Can the court provide some type of remedy that might be suitable? So those are essentially the three standards that any litigant has to meet. But you are correct, Chairman Powell, anyone can sue anyone else at any time for any reason. It doesn't mean it's a legitimate lawsuit or that it will succeed on the merits or that it will succeed procedurally. But you have to get into the fight, into the litigation, even find out if it's going to succeed. So you are looking at years of litigation if things don't resolve with passing this bill.
Thank you, Ms. Penich. You have no questions. The final witness we have today is Chris Nulowitz, and Chair.
I would like to thank Ms. Penich for her testimony today, and I certainly do. And you've been quite an education, but I may be the only member of the legislature who freely admits he's not an attorney.
Good for you. You
Thank you,
escaped.
Mr. Chairman. Mr. Nulowitz.
To the committee. My name's Chris Anulowitz, and I'm a litigation partner at Balch and Bingham here in Atlanta. For about the past 25 years, most of my practice has been devoted to litigation involving state and local governments, challenging regulations, challenging decisions of administrative bodies. Through its legislation, as Chairman Powell said a number of years ago, the General Assembly created the Georgia Access to Medical Cannabis Commission with the intent of allowing the regulated sale of medical cannabis in the state of Georgia and approving the issuance of 6 licenses for the production and growth of 2 classes of medical cannabis growth. Pursuant to the legislative grant, the commission put out a bid for issuance of those 6 licenses. As Chairman Powell said, almost 70 companies put in for those bids. Of those 70 companies, 6 were chosen in July of 2021, coming up on about 7 months ago. And I just, as a disclaimer, I do not represent and have not represented any of those 70 companies. I'm here today just to talk about like the process of an appeal or litigation that they might take. The challenges to the bid process that were made by 16 of the companies that were not selected. Those 16 challenges have been pending, as Ms. Panich said, before the commission for the past 7 months. There has been no resolution by the commissioner who is reviewing their initial challenges. And I don't understand that there is any decision that is forthcoming. So the commission is probably going to take a while. The commissioner who is looking at these things may take a while. There is no deadline, as I understand it, as to when he needs to make a determination. And accordingly, during that time, the provisional licenses are still that provisional, and the 16 challengers are 16 challengers. And that may go on for a significant amount of time. I understand, why I've not studied it, that the administrative challenges assert significant legal claims with regard to the fairness and propriety of the licensure awards. And again, they are still being processed. In order for those claims to go forward to the next level, you typically have to exhaust all those administrative remedies, and the administrative remedy is, again, for the commissioner to make a decision. Once the commissioner makes a decision as to whether or not the challenges will be granted, then, as Commissioner Powell said, those litigations, those litigants, the disappointed bidders can file a litigation in the Superior Court of Fulton County to appeal what the commissioner has done. Those can take the form, and most likely will take the form, because everybody wants to control their own destinies, of potentially 16 separate lawsuits in Fulton County Superior Court. When the courts are going to look at whether or not the licenses were appropriately granted, they're going to want to look at a significant amount of detail: what was submitted, what were the licenses based upon, what is the evidence that supports the license, and how did the commissioners make their decision? Was it arbitrary and capricious, or was it simply in accordance with the procedures that were set forth and authorized by them? In order to figure that out, there is going to have to be a significant amount of discovery, a significant amount of work that is done on behalf of the litigants in the court in order to get to a resolution as to whether or not these types of things are going to be overruled and whether or not the decision can be upheld. This process is, as Ms. Panich said, going to take quite a while. The wheels of justice do, in fact, spin very slowly. COVID has backed up our courts, both in the Superior Courts of Fulton County and elsewhere, and it is very unlikely that, absent some type of an emergency hearing, of which I doubt that these would be, that these cases would be heard anytime within the next year. After the litigations go forward, the litigants would have an opportunity, either the challengers, the 16 challengers, or perhaps the 6 licensees who have already gotten the licenses. They may intervene in these cases. They would have the opportunity to appeal to the Georgia Court of Appeals or to the Supreme Court. My guess is it would be the Court of Appeals, but you have an opportunity to go there and they would decide whether or not they want to accept the appeal. It's a special type. You have to petition for it. But my guess is because this is a new area of the law, a new commission, the Court of Appeals would want to hear this issue. That process would probably then take about another year. And then a disappointed person could then ask our Georgia Supreme Court to look at these issues, and that could take a significant amount more time. In other words, the process that is going to occur here in determining out whether or not the licenses are valid is likely a number of years away. And that has been my experience, having done this a lot of years. Ms. Panich said, she's got cases that have taken 4 or 5 years to get through the process. I've had cases that have taken 7 years to get through the process. It is a long one, and I don't see anything different happening today. As what I understand Chairman Powell's bill is going to do is he's saying, listen, we've got a legitimate legislative intent, which is a legitimate legislative purpose, which is to allow this product to be made in the state of Georgia. There have been impediments to allowing that happen. And in order to short circuit not short circuit, but in order to fairly adjudicate these things, allow that legislative purpose to go forward, and also be fair to the parties that have been involved, that the legislation, that his legislation would be preferable, both in terms of timing and fairness to the parties. And so, and that's, I think he's probably right.
Thank you. We do have a question, Representative Jackson. Oh, I'm sorry. Looking at the wrong number. Chairman Mitchell.
I have a simple question.
Yes, sir.
Testing, yes. Mr. Anulowitz, are you related to Representative Terry Anulowitz?
She might disclaim me, but yes.
Okay, great. I have a series of questions here then for you as a result. No, good to see you.
Good to see you, sir. Thank you so much.
Thank you very much for your testimony. There are no other questions. Thank you very much.
Take care.
I certainly want to thank you. And I certainly do want to thank you for taking time to come up here and to prove that I'm not an attorney, but I was right. Thank you.
Thank you very much.
Hey, ladies and gentlemen, we don't have any other witnesses. Well, I have another question.
No, just a move to pass when ready.
I was going to recognize Chairman Mitchell for that motion.
Hey, all right. Thank you, Mr. Chairman. It gives me great pride to be able to advance this legislation or make the motion to advance this legislation. So I do move do pass.
And there is a second from Chairman Carpenter. So we have a motion and a second for a do pass recommendation from the committee. And we have a third over here. Is there any discussion on the motion? Well, hearing none, if you favor this motion, please say aye.
Aye. Okay.
And if you oppose it, say no. And there is no opposition. Congratulations, Mr. Chairman, on the passage of this bill out of committee.
Great leadership.
We got another bill. Thank you so much, Chairman Washburn, and thank you to the committee members. Thank you to all of those who had testified. The easy job is now passed. I'd like to thank the young lady who gave us such a nice rendition on her ukulele. And of course, my dear friend, the rabbi. We just don't need to hear anything else about smuggling hash oil and condoms, but so good to hear all of these. This is certainly an interesting committee. To the folks who have, they're involved in this issue, I would tell you that you need to stay involved. This bill now goes to the House Rules Committee. And you need to reach out to the powers that be. And then God forbid, if it gets over to the Senate, it's a whole different day. Thank you so much. And we have a bill that we had postponed. And the bill that we had postponed was HB 884. And it's my understanding that some of our outstanding members, Representative Jackson and Carpenter, and several of y'all have worked out some language. And
Chairman,
copies of that language. All right. You may, if you'll press your button.
I just want to say that that spirit of bipartisan, cooperation, I don't know that that happens in other committees, but I think it's due to your leadership that was able to come to fruition.
Online, does he want to be recognized?
Anytime I advance legislation, it is good legislation, so it generally should be accepted without even contradicting or challenging it. So, of course.
Thank you to my dear friend, and thank you. And it sounds like it's an election year. We have online, we have Representative Walensky, and I apologize because he was also one of the group that helped to perfect an amendment. Did you want to address this, Representative Walensky?
Thank you, Chairman. I just wanted to say for procedural purposes, I'm here. That's all.
Very good. Thank you so much. All right, I've been handed in a language, and I apologize, it has not been printed up as a substitute. So what we're going to do is entertain this as language to a amendment to the committee substitute. And see how I've been around long enough, I knew how to figure that out, didn't I? So if we would, to the author of the bill, have you read the substitute?
Yes, sir. I agree with you. I agree with this amendment to this substitute.
All right.
And I'll also say that if helpful, I'll bring my banjo to the next committee meeting and play that for you.
You know what? I do appreciate it, but given the light that you seem to be having a hairless day, that you might need one of those caps like the rabbi is wearing.
Yes, sir.
We're going to take a pass on any further comment.
God bless you, sir.
If I might, Chairman Collins, since you were so proud to be involved and you were so helpful in this, would you like to read the amendment so that we're all on board with this?
Later than 30 days from the date of receipt of an application and information and documents that show that all of the requirements of subsection B of this code section have been met. Such application shall only require such information and documentation necessary to verify that the applicant meets the requirements set forth in subsection B of this code section.
Thank you so much.
That will replace lines 34 through 38 of LC 365186S.
So does everyone understand the amendment as proposed? Now, the chair will be willing to hear a motion. We have a motion on substitute to 884 LC 5186S. Do I hear a motion?
So moved.
Now, do I hear a subsequent motion to amend on lines 34 through 38 this language? We have a motion. Do we have a second? We have a second. All in agreement? Say aye. Aye. Any opposed? Now, second to the original motion as substitute to be amended. Do we have a second? We do. Any questions? Any further interest in this issue? If not, all in favor say aye. Aye. Opposed? And the ayes have it, and your bill goes to the Rules Committee as a committee substitute as amended. Been a long time since we've done one of those.
Yes, sir. Thank you, Chairman.
Ladies and
and thank you,
gentlemen, I
committee.
want to thank the committee members for your diligence. I think most of y'all were signers on to House Bill 1400. I would certainly encourage you to speak up and to encourage this because this is about fixing a system. And also talk to Jan because we do need a head count on a committee dinner.
Yes.
Please do.
If I can get a kitchen pass, I'll be there.
Thank you, ladies and gentlemen, for being here today, and this meeting is now adjourned.
Okay, will you sign